Swayam Prabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 20th lecture, which I am going to discuss. Today's topic is Justice to the Victim of Crime and Human Rights. In previous lecture, I have highlighted compensation to the victim of crime. Here, I am going to explain you justice to the victim of crime and human rights issues. So, this is more wider than compensation to victim of crime. Justice to the victim of crime, the moment we use this word justice to the victim of crime, it means we are talking about all the relevant remedies available to the victim of crime under criminal justice system. For example, how complaint can be made, what should be the procedure for making complaint to the competent authority, what are the rights which victim of crime can claim under criminal justice system, right to access to justice. This is another important component of justice to the victim of crime. If victim of crime is poor, if victim of crime is not in position to access justice due to poverty, on account of poverty, then how law would be helpful to him or her? I will also highlight that aspect. You see, the word used in this slide is justice to the victim of crime. So, in what way justice can be done with victim of crime? We will try to understand this concept in the light of statutory provision, in the light of constitutional provision, and with the help of judicial pronouncement, we will try to understand the entire concept of justice to the victim of crime. As you all must be knowing that Constitution of India, being supreme law of the land, guarantees certain rights as a fundamental rights to the citizen of this country. For example, right to equality. Every person is equal in eye of law, irrespective of caste, creed and religion. Every person is entitled to be treated equally. Every person has right to live with human dignity. Every person has right to express his or her idea. So, where a person who cannot access to the justice merely because of poverty, it would be injustice on the part of the state, where citizens of this country, they are unable to get justice from the court due to poverty. So, our constitution makers, they have specifically incorporated in our constitution, in the part 3rd of the Indian Constitution, that states shall endeavor to make special legislation for providing free legal aid to the poor people who cannot afford court fee or advocate fee. As you all might be knowing that Part 4th of the Indian Constitution, which talks about directive principle of state policy. So, Article 39A specifically talks about that state shall endeavor to make a scheme for free legal aid to poor people. But we should thank to the Supreme Court that Supreme Court in the year of 1978 for the first time held that right to free legal aid is a fundamental right. It is essential component of Article 21 of the Indian Constitution. So, no person can be deprived from getting justice merely because of poverty. So, I will discuss it in detail in coming session. Now, let us understand this concept, justice to victim of crime, with the help of this slide. You can just see. I have chosen who is victim of crime. According to section 2WA of the CRPC, victim of crime means a person who has suffered injury or loss individually or collectively dependent of the deceased, has also been covered in this definition. Victim of crime, it has three important components: restitution, rehabilitation, status quo ante. I just want to explain this justice to victim of crime with the help of this slide. You look at your screen. Restitution is the first component, rehabilitation is second, and status quo ante, this is the third purpose of justice to victim of crime. Compensation to victim of crime, this is also a kind of justice to the victim of crime, where victim has suffered loss, so that victim must be provided financial assistance. So, that is compensation to victim of crime. So, I would like to highlight these three important components of justice to the victim of crime. Restitution. Restitution here means restorative justice to put the victim of crime in that position if he or she would not have been, if her right would not have been violated. So, restitution here means to bring back the victim of crime, to provide all the assistance, legal assistance as well as financial assistance, medical assistance, shelter, all these things must be taken into account by the court while providing justice to the victim of crime. Where victim of crime has lost his shelter or her shelter, it is the duty of court to give order to the government to provide shelter to the victim of crime. Where victim of crime has suffered economic loss, then court may direct the authority to provide financial assistance, or court may direct the accused to provide financial assistance to the victim of crime. So, the purpose of justice is rehabilitation, restitution, and rehabilitation can be done by providing financial assistance, by providing shelter. So, these are the paramount concern of criminal justice system, that justice must be done with the victim of crime either by providing financial assistance or by providing legal assistance to the victim of crime. Legal assistance here means by providing advocate to the victim of crime, free of cost if victim of crime cannot afford court fee. Apart from this, the ultimate, as I said, the ultimate purpose of justice is restorative justice, restitution, rehabilitation. Before I start that aspect, restorative aspect or rehabilitation aspect. Here I would like to highlight the rights of victim of crime which he or she can claim under criminal justice system. As you all might be knowing that victim of crime can access to the justice, can mobilize the police system just by lodging FIR at the police station. Victim of crime can put police into motion just by lodging FIR or filing complaint to the magistrate. And once complaint is filed by a victim of crime, authority is bound, either magistrate may transfer that complaint to the police station, that station head officer should accept this complaint, start investigation and submit the charge sheet, or magistrate can take cognizance on the basis of that complaint, can issue warrant against the offender, against the respondent. So, you see, this is the remedy available to victim of crime. He or she can access to justice, he can file complaint, he can file or she can file complaint to the magistrate. As you all might be knowing that victim of crime, if he or she is not satisfied with the investigation or with the action taken by the magistrate, then he can or she can file protest petition in that very court where charge sheet is submitted or final report is submitted. So, victim of crime is not satisfied with the report, with the investigation, she can make a protest petition in that very court where final report is submitted. So, this is another effective remedy in the hands of victim of crime. Just by filing protest petition, he or she can convince the higher court, that subordinate court or the investigating officer, you say he or she can, victim of crime may ask the court that investigating officer has not completed the investigation in true sense, and matter if court is convinced, court may pass order in favor of victim of crime and order for reinvestigation may be given to the police officer. Police officer will have to re-investigate the matter. Now, come to this constitutional aspect. Let us understand constitutional aspect of victim of crime, how Indian Constitution has been helpful in securing justice to the victim of crime. You just can see with the help of this slide. Look at your screen. I have chosen three important components, three important constitutional provisions. Right to life, Article 21. This is very important provision. Again and again I have been repeating this right to life as a fundamental right, as a human right. Without this right, we cannot imagine justice to the victim of crime. PIL as a means for protection of rights of victim of crime, and Article 23, 20 clause 3, which talks about protection against self-incrimination. Now, let us understand this PIL, public interest litigation, and victim of crime. How public interest litigation has taken care of the plight of victim of crime. So, this public interest litigation, here you see I have used this two important case laws. With the help of these two important judicial pronouncement, I will try to explain these two cases so that you can understand the entire perspective of victim of crime. PUDR versus State of Bihar, AIR 1987, farmer's death by police atrocities. I have just highlighted this case in my previous lecture. And Saheli, a women resource center versus Commissioner of Police. You see, these two cases are leading cases on this point. PUDR, this case I have just referred. So now I would like to highlight the facts of Saheli case, Saheli versus Commissioner of Police. You see what happened in this case? In this case, a 9-year-old child was brutally killed in police lockup, and the mother of the deceased was a domestic servant. She was not in position to fight her case. So this non-governmental organization, NGO, decided to fight the case of that poor lady, and she filed a petition in Supreme Court by highlighting the facts before the Supreme Court that it is a case of custodial death and the deceased lost his life in police lockup, and police personnel who had called him to interrogate a matter. When inquiry was conducted in this case, court found all the allegations true, and Supreme Court held responsible the police commissioner of Delhi, commissioner of police Delhi, you just correct it. So commissioner of police Delhi was held responsible in this case, and Supreme Court directed the government concerned to provide compensation to deceased mother. So here you see, deceased mother was also considered as a victim of crime by the Supreme Court. The point which I want to make is that even the deceased mother was also considered as dependent of the victim of crime, dependent of the deceased. So mother was awarded compensation by the state government, and Supreme Court directed the government to provide adequate compensation in this case. So this case is important. You see how Supreme Court took cognizance of a case where NGO had filed a petition in this case, PIL. So you see, PIL can also play important role, and PIL has been effective in providing justice to the victim of crime. We have seen these two important case laws where PIL, these two cases were brought into the notice of Supreme Court with the help of public interest litigation. Third important case, PIL as a means for protection of rights of victim of crime. You just look at your screen. I have used this word PIL as means for protection of rights of victim of crime. How public interest litigation has proved its efficacy in recognizing rights of victim of crime. There are two important case laws. You see, Hussain Ara Khatun versus State of Bihar, AIR 1980, Khatri versus State of Bihar, AIR 1980, Supreme Court. This Hussain Ara Khatun case, I have referred this word women prisoner case. Khatri versus State of Bihar case, Bhagalpur blinded prisoner case. As I said, where victim of crime is not in position to fight his or her case due to poverty, then anyone can fight his case. Any person who has interest in public cause may come forward and may fight his or her case, may file a petition in High Court or Supreme Court under Article 226 and 32. This is the theoretical aspect of PIL which I have just referred, that anyone, any person who has interest in public cause, public welfare, can fight the case on behalf of poor people or group, poor persons. So in this case, in Hussain Ara Khatun case, as I said, Hussain Ara Khatun, she was languishing in Bihar jail for so many years, and since she was not in position to fight her case due to poverty and she was ignorant about her rights, she did not have idea about her rights, or neither she was in position to fight her case because she was poor. So this matter was brought into the notice of Supreme Court by one leading lawyer of that time, Kapila Hingorani. So she mustered her courage to fight this case, and in this case, Hussain Ara Khatun, she was a prisoner, and there were 7 prisoners along with Hussain Ara Khatun who were languishing in Bihar jail for so many years. So the matter was brought into the notice of Supreme Court, and Supreme Court accepted the contention of plea of the advocate counsel who was appearing on behalf of Hussain Ara Khatun, and Supreme Court directed the government concerned to provide compensation to the prisoners who were languishing in prison for so many years, and Supreme Court also issued direction against the government concerned that all the prisoners must be released from the jail who had to remain in jail for more than required period if they would have been convicted by the court. So they must be released, and you all might be knowing that. You will be surprised to know that because of judicial intervention, many prisoners were acquitted, were released, and it is said that it is about 40,000 prisoners were released across the country. That is only because of judicial intervention. Khatri vs. State of Bihar AIR 1980 Supreme Court. This is another important case, leading case on PIL. As PIL has played important role in protection of rights of victim of crime. Khatri vs. State of Bihar. So this case is popularly known as Bhagalpur blinded prisoner case. So quickly I would like to summarize this case. Quickly I would like to highlight this case. In this case, about 14 prisoners, they had lost their eyes during interrogation. So since they all were poor and they were not in position to engage their counsel in the court of law, due to poverty they were not in position to pay court fee or advocate fee. Since they had lost their eyes, they were victim of crime. So being victim, matter was brought into the notice of Supreme Court by a leading lawyer. So Supreme Court took cognizance in this case and Supreme Court intervened in this matter. You see what the point which I want to make it clear is that where victim of crime cannot access to justice, it would be denial of justice. And the ultimate purpose of justice is restorative justice. Ultimate purpose of justice is to repose confidence in justice delivery system. So if people will lose their confidence in justice delivery system, it would be very fatal, it would be very bad for any democratic country. So to repose confidence in justice delivery system, it is the duty of court to ask the accused as well as victim of crime whether victim of crime is in position to engage his counsel or her counsel before the court of law or not. You see, the irony of law is that criminal justice system has always been concerned about the rights of the accused, and the golden rule of criminal justice system is presumption of innocence. Every accused is presumed to be innocent unless his guilt is proved before the court of law. This is a golden principle of criminal jurisprudence, that every person must be presumed innocent unless his guilt is proved before the court of law. So, because of this presumption, Indian criminal justice system has been focusing, emphasizing on rights of the accused, not rights of the victim of crime. So, victim of crime has never been focal point of Indian criminal justice system. If you will make thorough analysis of Indian criminal justice system, you will find that it was the year of 1980 when Supreme Court started intervening in the interrogation system. Supreme Court started intervening in the functioning of the police, malfunctioning of the police investigation, and because of judicial intervention, we can see that victim of right, a victim of crime has been put at focal point, has victim of crime has been put into the center of Indian criminal justice system right now. So, how Indian criminal justice system has shifted from focusing on accused, emphasizing on the rights of accused, to giving more emphasis to the victim of crime. You can refer Khatri case, you can also refer Hussainara Khatun case. Here you see, this was the year 1980, 1978, 1979 when Supreme Court started giving more emphasis on the rights of the victim of crime. And in the year of 2003, when Malimath Committee considered the gravity of this issue, and this committee, Malimath Committee, has suggested that victim of crime must be put into the center of Indian criminal justice system. The rights of the victim of crime should be protected, should be recognized by our legal system. If we see that international instrument, international organization, or particularly what is the contribution of United Nations General Assembly about victim of crime, you all might be knowing that in the year of 1985, United Nations General Assembly for the first time passed a resolution on the powers of victim of crime and its abuse. 1985 United Nations General Assembly resolution on rights of the victim of crime 1985, that is a milestone in the field of criminal justice system. And when that resolution was adopted by United Nations General Assembly, in order to provide, in order to recognize rights of victim of crime, all the member states, all the signatory member states who had put their signature, who are the party to that resolution, they have taken responsibility to protect and recognize the rights of victim of crime. So, now let us see other judicial pronouncement where Supreme Court has played important role in providing justice to the victim of crime. Here you can see on your screen that I have referred to leading cases: Vishakha versus State of Rajasthan, AIR 1997. Bodhisattva Gautam versus Subhra Chakravarti, AIR 1976. Vishakha versus State of Rajasthan case. You might be aware about this case. What happened in this case? You look at your screen, sexual violence at working place. I have chosen very specific words in this case which are important for you at this, those words are very important for you at this point of time. You see, Visakha case is regarding sexual violence at working place. In this case, what happened? Bhauri Devi, this case is also known as Bhauri Devi gang rape. Establishment of Women Grievance Cell, WGC, Women Grievance Cell in every department, government department or private department, is mandatory. So, this is a leading case on sexual violence at working place. How you see how this case, how Visakha guidelines have been effective in providing justice to the victim of crime. You see, in Visakha case, what happened? I just want to highlight the facts of this case, Visakha case. What actually happened in this case? A village head, Bhauri Devi, she had been involved in creating awareness among the people, society. She was village head, she was Sarpanch, village head, and she was trying to convince local resident of Rajasthan against child marriage. That is one important social evil in Rajasthan at that time. Child marriage, which was rampant, which was on rise during that time. So, she decided to create awareness in the society. So, for that reason, one day when she was creating awareness about child marriage, so that incident took place against her, and matter was, you see, the matter was brought into the notice of Supreme Court that a village head, Bhauri Devi, she was gang raped by few people of a village. So, Supreme Court, you see, Supreme Court asked the state government concerned, state of Rajasthan, and central government, that whether central government or state government are having such a special legislation for the protection of women from sexual violence at working place. So, neither central government nor state government could provide information, satisfactory information regarding legislation which can protect a female from sexual violence at working place. Means central government and state government both submitted a report in the Supreme Court by saying that they do not have a special legislation for the protection of women for such kind of thing. They do not have a special legislation for the prevention of sexual violence at working place. So, government, central government as well as state government both were directed by the Supreme Court that unless these guidelines are legislated by the parliament, guidelines issued by this honorable court shall be treated as law of the land. So, Supreme Court issued guidelines, in this case Visakha guidelines. You all might be, the important guideline which you all need to remember, that Supreme Court for the first time held that every organization, whether it is private or public organization, must have women grievance cell, and women grievance cell must redress the grievances of women pertaining regarding sexual violence, so that the human rights of the women at working place can be protected. So this is another important case where Supreme Court has issued various guidelines for the protection of rights of women, and in this way we can say that justice to the victim of sexual violence has been done by the Supreme Court. This is very leading case on this point. Another important case on this point is Bodhisattva Gautam versus Subhra Chakrabarti. You see, before the pronouncement of this judgment, the earlier notion was that human rights cannot be enforceable against the private individual. But in this case, in Bodhisattva Gautam versus Subhra Chakrabarti, Supreme Court for the first time held that even fundamental right can also be enforceable against private individual, where an individual has violated the fundamental rights of another individual, that aggrieved can file a petition under Article 226 or 32 of the Constitution for the enforcement of fundamental right, for the protection of his or her fundamental rights. He or she can file a petition under Article 226 or 32 of the Indian Constitution. Bodhisattva Gautam versus Subhra Chakrabarti. So in this case, you need to remember this case for two reasons. The first is, this is the case when Supreme Court held that fundamental right can also be enforceable by one individual against another individual. Second observation which Supreme Court has made in this case is, that is about interim compensation. Supreme Court said that interim compensation can be awarded to the rape victim. So rape victim is entitled to get interim compensation from the accused, from the wrongdoer, till the case is finally disposed of by the trial court. So she can get compensation as a matter of right. This is another. There are two. I have highlighted the role of Apex Court, Supreme Court. You can see on your screen. I have referred all these cases so that you can get entire information. The third important case on this point is Chairman Railway Board versus Chandrima Das, AIR 2000, and Ruddal Shah versus State of Bihar, AIR 1982, Supreme Court. So you see, one thing which you need to remember, in my previous lecture I have just referred compensation to victim of crime. Here in this lecture I am highlighting justice to the victim of crime. So justice to victim of crime and compensation to victim of crime both are totally different. Justice to victim of crime is a wider term. It includes within its study compensation to victim of crime. So compensation to victim of crime is one small component of justice to the victim of crime. So whatever means, whatever methods can be adopted for what? To provide justice to the victim of crime shall be included in the head of justice to the victim of crime. But in compensation to the victim of crime, we have to confine ourselves towards statutory provisions or role of Supreme Court towards compensation to the victim of crime and nothing else. So that is why I have covered two cases only, Chairman Railway Board versus Chandrima Das and Ruddal Shah versus State of Bihar, AIR 1982, in this compensation to victim of crime. So by doing so, we can also do justice with the victim of crime. If state is providing financial assistance by compelling the accused criminal since that offender has violated the rights of the victim of crime, so that offender must be compelled to provide financial assistance to the victim of crime. So, I have chosen these two important case laws, assuming that you all have understood this concept. Now, let us understand statutory provisions for victim of crime. You just look at your screen. I have referred three important sections: section 357 CRPC, 357A, which talks about compensation scheme, and 357C, which talks about medical treatment, and 358 CRPC. Second is Provision of Offenders Act 1958. So, let us try to understand this statutory provisions for victim of crime. In this slide, I will try to explain you what are the statutory provisions which are exclusively enacted for the betterment of victim of crime, to provide justice to the victim of crime. What are the statutory provisions? What are the procedures through which justice to the victim of crime can be provided, can be ensured? So, I have chosen this section 357A CRPC. One important thing which I want to explain you in this head, that is section 357C. What is section 357C? Section 357C was inserted by Criminal Law Amendment Act 2013 and 18. So, Criminal Law Amendment Act 2013 and 18, these two important amendments are very important. For example, by these amendments, obligation has been imposed upon the state, upon the authority, to provide medical assistance to the rape victim, to provide medical assistance to the victim of crime. So, that is why section 357C CRPC is very important, which talks about every hospital, whether it is government hospital or private hospital, shall provide medical aid free of cost. So, no medical institute, no medical nursing home can refuse to provide medical assistance to the victim of crime merely on the ground of fulfilling medico legal formality, merely on the ground of poverty, merely on the ground of that without fulfilling medico legal formality, that hospital will not provide facility, first medical aid to the aggrieved. It would be a crime, and where authority has failed, where government or government officials has failed to provide first aid or medical aid free of cost, it would be violation of statutory provisions and action can be taken against. So, this is another important aspect of compensation, rehabilitation, restitution. So, medical aid, first aid, these are the remedies available to the victim of crime. So, this is restitution or rehabilitation in form of medical aid, medical assistance will definitely serve the purpose of criminal jurisprudence, will definitely serve the purpose of Indian criminal justice system. I must say that Parliament, after inserting section 357A and B, A, B and C, has fulfilled international commitment where government expressed its international commitment in ICCPR or UDHR 1948. So, if you all remember all these things, I do believe that you all have understood. Now, come to third important aspect of justice to victim of crime. Third important aspect, a role of Supreme Court in protection of victims' right. How far Supreme Court has been effective in protection of victims' right, in protection of rights of victim of crime. I have referred two important case laws, Delhi Domestic Working Women versus Union of India, AIR 1994, Nilavati Behra versus State of Odisha, AIR 1993 Supreme Court. That case is popularly known as custodial death. So, in case of custodial death, police officers along with constables, they would be held responsible. I think I have highlighted several judicial pronouncements so that you can get entire information about justice to the victim of crime. Now, apart from this constitutional provision, statutory provision and role of Supreme Court in protection of rights of victim of crime, I would like to explain two important components which must be addressed under criminal justice system. They are right to legal aid and right to free legal aid. You just see, you just look at your screen. I want to right to legal aid, right to access, and second is right to free legal, right to free legal aid. This is, I just want to, you look at your screen. Second is right to free legal aid. Both were same. Now you correct it. Right to legal aid and right to free legal aid. How these two things are concerned with justice to the victim of crime? You see, the topic is justice to the victim of crime. So, no justice can be done to the victim of crime unless it is ensured by the court that victim of crime who has come before the court has been represented by a counsel. So, without legal representation, if case is decided by the court, by the criminal court, that decision would be void in the absence of statutory provision. This is another aspect, right to legal aid, where victim of crime is unable to fight his case or her case. So, government has decided to empower them with right to free legal aid. So, right to free legal aid, as you all might be knowing that these two things are specifically mentioned under Article 20, clause right to legal aid 22 and right to free legal aid. So, justice to the victim of crime would be incomplete where victim of crime is poor, unable to come before the court, unable to engage his or her counsel before the court due to poverty. It would be justice to the victim of crime would be incomplete unless Indian criminal justice system has effective advocates, Indian criminal justice system has provision about legal aid free of cost, about legal representation. Only then we can ensure this Indian criminal justice system in a real sense. Otherwise, it would be meaningless where a victim of crime who is deprived from getting justice due to poverty, he or she is not in position to fight his or her case due to on account of poverty. So, right to legal aid and right to free legal aid, these two things are essential component of justice to victim of crime. Right to have access to justice is also important component of free component of justice to victim of crime. So, as you all might be aware about M.H. Hoscott, in M.H. Hoscott versus State of Maharashtra, AIR 1978 Supreme Court for the first time held that right to free legal aid is a fundamental right, it is essential component of right to life. So, where victim of crime, she cannot afford or he cannot afford his or her case due to poverty, it is constitutional obligation of state to provide legal aid free of cost. A right to life would be meaningless for that victim of crime who is unable to get justice due to poverty. Right to life would be fiasco for that victim who cannot get justice due to poverty. So, right to life would be secondary for that victim of crime if that poor victim of crime is not provided free legal counsel free of cost. So, with this idea, Supreme Court in 1978 for the first time recognized that right to free legal aid is a fundamental right, essential component of right to life and personal liberty. So, I have chosen this topic, justice to the victim of crime and human rights. So, whatever methods you can, whatever procedures you can find out in our legal system, in our constitutional scheme, you must refer, you must understand that all the procedures prescribed in statute to provide justice to the victim of crime, all the methods and procedures prescribed in our constitution to provide justice to the victim of crime, that must be covered. A right to have access to the justice, legal representation, restitution, rehabilitation. So, I have covered each and every aspect of justice to the victim of crime. Justice delayed is justice denied. If justice is delayed without sufficient reason, without unreasonable, without cogent reason, justice delayed is justice denied. So, criminal courts are supposed to provide justice within prescribed time, and if criminal justice system can provide justice to the victim of crime or procedures are followed, then without any hesitation we can say that Indian criminal justice system, Indian Supreme Court has played significant role in providing justice to the victim of crime. You can Nilavati, I have also referred Nilavati Behra case, PUDR case, Ruddal Shah case, Khatri versus State of Bihar case, Shaheli versus Police Commissioner Delhi case, Delhi domestic working women case. So, all these cases are directly connected with justice to the victim of crime. So, I do believe that whatever things I have just discussed in this lecture, you all have understood the things. If you all can refer all these things, if you all can remember all these things, definitely you will get success in your coming examinations. With this, I would like to conclude this lecture. Thank you all.
Hello everybody. Now the discussion which I would try to make talk to you is about the excitement which I always feel, and I am sure you will also reciprocate as I proceed and when you do the course, is in the area of multivariate statistical problems and multivariate statistical analysis. So, what we mean by multivariate? So, we know that statistics is a subject where you have a lot of data, you try to analyze that using different type of techniques like estimation problem, MCMC techniques, then forecasting and the area of time series analysis, and then try to basically find out the best forecasting tool which you have, such that you are able to gain the maximum amount of information from a set of data. Now, in the recent past, as we see that multivariate statistics has really increased in a very exciting manner, and if I trace back to history, it has been going on slowly for the last about 70-80 years, but now the time has come where it is being used in a very big way, and the techniques which we all know, but which are being utilized with new vigor are in the area of, say for example, canonical correlation technique, in the area of factor analysis, in the area of conjoint analysis, in the area of clustering analysis, in the area of multi-dimensional scaling techniques, structural equation modeling, be it in the area of finance, be it in the area of engineering, be it in the area of social sciences, be it in the area of economics, such that you are able to gather the information from the data in such a way that it really gives you some useful set of information. Now, in the recent past, there has been also an explosion of large and complex data sets, but added to that there has also been a commensurate increase in the computing and the statistical techniques. So, obviously, the question comes that if the statistical techniques are there for so called small data, not the big data, not the data which is of terabytes and so on and so forth, where you use different type of computers to store the data, the question obviously comes that are those statistical techniques really relevant when we use them in the big data sense. The question is, they are not always relevant, they may not give you the best results. So, what we are seeing in years to come, and I feel very excited about that, is that how the new tools which we have already learned in statistics, in multivariate statistical analysis, are being redrawn, are being, say for example, remodeled in such a way that they can be utilized along with the techniques of computing in a very nice manner, that we are able to garner the information from big data very successfully and very nicely in such a way that they are able to portray a sense of information which we all long to have from big data, be it in, say for example, medical sciences, be in the area of finance, be it in weather forecasting, be it in transportation, so on and so forth. So, obviously, it means that students, participants who are in a position with some brief mathematical background to take multivariate statistics and statistical tools as a subject in this program are assured of a very exciting future, where they can use these tools to both gain the knowledge as well utilize them in a very best practical sense, such that they are able to do some justice to the information which is given to them and get the best information from the data sets. I wish all the participants in this course the best of luck, and I am sure they will also reciprocate the excitement which I have for this type of courses. Thank you.